They're schemers. Schemers trying to control their little worlds. I'm not a schemer. When the chips are down, these civilized people, they'll eat each other. And here we go.
Well, hello there, you amazing, beautiful, wonderful people. I hope you are all well on this thirsty Thursday. That's it, baby. It's Thursday. We're getting through the week, and today we've got a busy day. In this one, I'm just going to go over a document that was dropped yesterday in the because we got this hearing today, which I'm going to be live streaming later on today, which is going to see whether the gag order is lifted in the Idaho 4 case. I am kind of feeling that the likelihood is it won't be lifted until after sentencing, because ultimately Bryan Kohberger could retract his plea. I know it's unlikely, but it's not impossible. And with the fact being that there could potentially still be a trial, it could be just enough for Hitler to say, look, no, I appreciate where you're coming from, but this does need to stay in place until after sentencing, so we know that this isn't going to go to trial. There wouldn't be any argument after that, considering that they have removed the ability for Bryan Kohberger to appeal. So, look, we'll see how that goes. But this document here, which I feel is interesting. Now, like I say, later on we're doing the hearing, and I'm also, just before that, going to be addressing apologies. Apologies around the Idaho 4 case, as a video was brought to my attention yesterday. And I'm going to be addressing that. If you're not subscribed, subscribed. If you haven't liked the video already, like it. Like it. Do it now. Do it now. Bit of Arnold Schwarzenegger there. I know that was hard to tell the difference between me and him. Right, so this is a declaration of Rebecca Boone in support of motion to be heard and unseal records. And why is this document extremely interesting? So for that reason, we have to come down to here, right? So I'm going to start here. Number 7. We understand that the court must balance the Sixth Amendment rights of the accused with the First Amendment rights or interests of the media, which serves as a proxy for the public. We do not seek extraordinary access now. Rather, it is our hope that the court will simply reweigh its balancing of Sixth Amendment and First Amendment rights now that Mr. Kohberger has pleaded guilty. Court records should be unsealed at the earliest opportunity, right? Idaho Court Administrative Rule 32 opens with a policy statement. The public has a right to access the Judicial Department's declarations of law and public policy, and to access the records of all proceedings open to the public. That statement can be served as a guiding star when weighing whether court documents should remain sealed in the weeks ahead, particularly once a jury is seated and the trial is set to begin. And again, just ignore the verbiage in here, because we're getting to the point here where she is going to basically speak about the Idaho 4 case and how that differs to any other case that she has dealt with in over 2 decades. While not every court document in this case is included on the Idaho Supreme Court's Cases of Interest website, an examination of the documents listed allows us to get a sense of the overall level of secrecy imposed by the court in this case. On June 26, I counted each order listed in the online case file, and then counted each order to seal. I did not include stipulations to seal or motions to seal in my assessment, nor did I include orders to redact rather than seal. Since this case began in 2022, there have been 465 orders issued by the court. More than half of them, approximately 246 in all, are orders to seal. 6 are orders to unseal. When the proceedings were being held in Latah County, the bulk of the sealing occurred at the beginning of the case and was mostly limited to material that had been returned from search warrants to internet and phone providers, banks, and the like. The majority of orders to seal have been issued since the case was moved to Ada County, And it is perhaps worth noting that the number of sealed records in this case has skyrocketed in 2025. Of 168 total orders issued by this court since January the 1st, 2025, more than 2/3 of them, 103 in total, have been orders sealing documents from public view. Without being able to view the records, I can only speculate as to why that may be. Perhaps it is because the case was getting closer to trial. Perhaps it is because of the amendments to Idaho Court Administrative Rule 32 that took effect this year, lifting the requirement for a hearing before records may be sealed. Perhaps it is simply an anomaly. Regardless, there are more sealed records in this case than I can recall in any case I've covered for the Associated Press over the last 23 years. A substantial portion of the evidence, arguments, and rulings in this case have been delivered in the form of written documents rather than in open court. The documents are as much a part of the court process as anything that happens inside the physical courtroom, and as such should be open to the public. Many of the sealed documents have been kept secret in order to ensure that a fair and impartial trial or jury can be seated so that the defendant can receive his constitutional right to a fair trial. Now that a jury will not be impaneled, the court should unseal the documents and honor Idaho's constitutional promise of open courts. In court systems as small as Idaho's, practices in one courtroom can easily set the culture for other courtrooms. That is why it is crucial that transparency and access are scrupulously maintained in every case, but especially in high-profile cases. There is no longer any risk of tainting a jury pool in this case. It's arguable there. It's arguable because, again, he could pull his plea. Mr. Koberg has reached a plea deal with the state and has pleaded guilty in exchange for consecutive life sentences. He has waived his right to a fair trial. I respectfully urge the court to reweigh the balance of the First Amendment right of the press and the public against the concerns that led to the increased secrecy in this case, and suggest that such a reweighing will likely lead to unsealed court documents. I declare, under the penalty of perjury under the laws of the state of Idaho, that the foregoing is true and correct. So people talk about this case, don't they? They talk about the Idaho 4 and they're sort of, why can't you leave it? Why can't you drop it? This, that, and the other. They're talking about it. And I touched on this yesterday, right? And I will touch on this again later on in this video that I do to address the apologies. But it's simple, and it's something that I've always said. You want an accused person to have a fair trial. But there is a fine line when it gets to a point where everything has been hidden. This person here, been in the media for 23 years and dealt with copious amounts of trials and, do you know what I mean? And then she comes forward and she looks at this case and it's like, why is everything being hidden? An unprecedented amount of secrecy. Now, if this was a slam dunk case, if this was just simple that all these people who doubted or thought Brian Koberger might have been innocent, and people turn around saying, but there's much more, you wait and see. If it was like that, then why so much secrecy around it? Because the secrecy is what leads to holes. And when there are holes, those holes are naturally filled. And they're filled with speculation. And look, someone's going to be right, someone's going to be wrong. But it's whether that speculation is right or is wrong. But you can't take away people's natural curiosity. People will wonder what the fuck is going on when they are not told what's going on. But when you are looking, and I said this yesterday, when you are looking to potentially execute someone or strip them of their freedom for the rest of their life, then I believe that every single thing around that should be transparent, absolutely transparent. And even to the point where when an accused person turns around and says, yeah, I did it, because of the historically, we know that people can and will be leveraged into taking pleas because they are afraid of ramifications if they do not do so. Again, that is even more of a reason for it to be transparent and potentially for an accused person looking to plea to be forced to address publicly some of the information around it. Now, I'm not saying that they should be forced to tell us why they did it and how they did it, but there should be something. Now, whether that be the fact that in the Idaho 4 case, there is currently no weapon, we don't know what was done with the weapon, we don't know what was done with the clothes or anything like that. Maybe it should just be that this individual should be forced to address that publicly, just to at least answer the question, which I fucking know that there will be doubts in people's minds closer to this crime than us on this platform, that there is a niggling feeling in their mind. Did this guy actually do it, and did he do it on his own? And there should be things put in place, measures set in place, that if he wants to plea and avoid execution, because what I will say, the flip side of the coin is, if Brian Koberger did 100% do this crime, then he absolutely deserves to be executed. And I raised this issue previously, and that is, if Brian Koberger can commit this heinous crime and walk away with a plea deal, then I'm telling you now, Idaho will never ever be able to refuse a plea deal to another individual again. Because can you get any more heinous than this crime if it is as simple as we are being led to believe it was? That this individual goes from Washington to Moscow to commit this atrocity. Another niggling feeling I have in the back of my mind that doesn't, to me, make sense, and I have to digress here a second, is that why would an individual who was looking to kill, who seemingly has no connection whatsoever to the victims, so in theory, this was just about killing, so why did this individual not kill in Washington, which is a non-death penalty state? Why would they travel 9 miles to a death penalty state to then kill, get caught, and then be scared of the death penalty? They could have just killed in their own state and just gone through the process, and maybe they walk. Maybe it's a hung jury. Who knows? There's little things like that always lead you to think, there's little things that don't make sense. But look, like I say, I digress. But the point being, we're in a position where we've got a hearing coming up later today. There may be this gag order lifted. Maybe they will. Maybe they won't. Maybe they'll leave it until after the sentencing, which I think is the most likely outcome here. But we've got a case that has been shrouded in secrecy and gag orders placed upon it by both the prosecution and the defense. Decisions made that seemingly don't make a lot of sense in the grander scheme of things, such as the house being torn down, buried, to then make a not-to-scale model of it, to then show that in court. I don't get it. And again, that's just one of the many things around this case that doesn't entirely make sense to me. We've got specialists who have been in their trade, such as Cy Ray, for multiple decades, coming out and saying evidence exists, what the prosecution are saying don't exist, to the point where the judge is turning around and calling these people conspiracy theorists for But let's not forget, the person you're calling a conspiracy theorist isn't a YouTuber. You're telling someone that they're a conspiracy theorist who has worked alongside FBI, been inside law enforcement, and worked in digital forensics for over 2 decades. Now, they're telling you something very simple, and the judge is saying that this person's a conspiracy theorist. So again, just adds to the melting pot of what the fuck is going on. Tell me I'm wrong. Love you all, and I will catch you all a bit later today. Mwah.